So in this video, I'm going to address how a disclaimer, also called a renunciation, can be an effective after-death estate planning tool. Hey, I'm Paul Rabelais. I'm an estate planning attorney here in Louisiana, helping people all over South Louisiana make sure their legal affairs are in order. I've got my book right here, 4th edition, just came out just a couple of weeks ago. You can get that on Amazon.com. I suggest you subscribe to the YouTube channel. Maybe check out our website, RabelaisEstatePlanning.com, or if so inclined, give our office a call to start a conversation about how to protect what you have. But I want to talk briefly about this not often used but can be effective estate planning tool, kind of after-death estate planning tool called a disclaimer or renunciation. Sometimes, believe it or not, it makes good legal or tax or financial sense to formally go through the process of refusing an inheritance and allowing it to pass on to others who would receive it in your absence. Let me give you maybe 3 examples. Let's say dad dies and he leaves assets to mom, and mom doesn't really need those assets, and she doesn't want to deal with perhaps the tax consequences either at an estate level or an income tax level of receiving those assets. So perhaps she disclaims or renounces, we'll get to those terms in a minute, that inheritance that she would have received from dad, and allows it to go on down to perhaps their children who would receive it, had mom predeceased dad. So that's an example. That perhaps could be done for just emotional reasons, or mom wanting to help out the children, see them enjoy some of the inheritance from dad. Or maybe mom dies and mom has, let's say, 2 children, and one of the children says, you know what, I don't really need the assets I'm getting from mom. I'm going to disclaim it, because if I disclaim it under the terms of mom's governing documents, those assets would go on down to the child's children without the child having to receive it and give it to the children and have to deal with all of the estate and gift tax annual exclusion limitations. So we see that sometimes. Sometimes an IRA owner dies, and most of you are aware that there are income taxes due on distributions from a traditional IRA. Sometimes the primary beneficiary of that IRA may say to himself or herself, you know what, I just don't want to deal with it. I don't need this money. I don't need the income tax consequences of inheriting an IRA. So I'm going to disclaim it, and it goes on down to the contingent beneficiary, who may need it more, or who may have better, because of their age, required minimum distributions. So that's another area where disclaimers can be effective. Let's talk about what all that means. And so I've used the term disclaimer and I've used renunciation. Disclaimer is really a federal term, really a federal tax term. So in order for someone to do a disclaimer, which means they don't accept it, it goes on down to others. That disclaimer has got to be in writing, got to be done within 9 months of death, and then the person who's disclaiming can't receive any of the benefits. So, after dad dies, mom can't run to the financial institution, put that IRA in her name a month later, and then say, oh, well, I'm still within the 9 months, I'm going to disclaim it. Can't do that. She can't accept any of the benefits of it. So there's a small window from the time of death until this stuff gets settled, where those disclaiming decisions must be made and put into effect. So you really got to make sure you're working with somebody who understands this stuff. Renunciation is really a Louisiana term for it. So someone who's inheriting in a succession or probate can renounce, again, not accept any of the benefits of it, and let it go on down to either whoever it says in the governing documents. Sometimes wills and trusts say, I leave it to so-and-so, but if so-and-so disclaims or renounces, then I leave that to so-and-so. So that would control, if that kind of language is not in the governing documents, then it's typically treated as if that disclaiming person predeceased the person who died. So know that that's the case there. A couple of situations where you may think a renunciation would be helpful, but it really isn't. You can't renounce in order to get out of paying your debts or to get out of paying for nursing home expenses. So I'll give you an example. I've got our Louisiana rules here that says that a creditor of a successor, so that's say someone's inheriting but they owe somebody $100,000, $1 million, whatever the case may be, that creditor of a successor may, with judicial authorization, accept succession rights in the successor's name if the successor has renounced them in whole or in part to the prejudice of his creditor's rights. So if you owe the bank $1 million, bank can, and you tried to renounce to get out of paying that debt, bank can come in and accept the part that you renounced. And then there's a nursing home situation, and I've got that rule right here. And so you're going to see the part I circled, which talks about waiving the right to receive an inheritance. You know, sometimes dad dies, leaves assets to mom. Mom's got to go into the nursing home, so they're thinking, no, mom, why don't you refuse dad's inheritance, let it go on down to the kids. Those assets are protected. That's not the case. So if a person is applying for Medicaid because they're in a nursing home and they are entitled to inherit, but they waive or renounce or disclaim what they're entitled to, then really it's treated as if they accepted it and then they gave it away, triggering all of the 5-year look back and the penalty provisions that Medicaid has for giving things away or making uncompensated transfers of assets. So this is an area where when it's effective, it can be really helpful. You have 2 windows of opportunity. You have the window of opportunity after somebody passes away. This is one of the only areas where you can actually do some post-death planning to keep stuff in the family. And so you have that window of opportunity before anything gets transferred to a potential disclaimant. And then you have the window of opportunity as you're getting your estate planning program prepared to incorporate provisions for what happens if somebody does disclaim or renounce something that they're entitled to. So really important that you get good advice, get it right the first time, work with the right people so that you do get it right the first time. Be aware that these things exist, and as there's more and more kind of government intrusion, I'm envisioning kind of more and more families wanting to incorporate this kind of either pre-death or post-death planning to preserve what they have. Hope that helps. I'm Paul Rabelais. Have a great day.